Welcome back to the deep dive. You've pointed us towards a really fascinating case this time. Mexfield Housing Cooperative Ltd v. Berrisford.
On the face of it, just a regular occupancy agreement, right?
Looks that way. But it ended up in the Supreme Court with, well, quite a surprising twist.
Exactly. It turns out that for an individual tenant, if the agreement really limits how the landlord can end things, it might kind of magically become a 90-year lease.
That's the nub of it. And it's what we're going to unpack today. You sent over the full case analysis, the judgment itself.
Yeah, because you really want to nail down the key takeaways. Like, how did the court handle an agreement with no clear end date? What does it actually mean for landlords, for tenants?
So our mission today is to cut through that legal complexity. We want to get to the heart of the issues, the Supreme Court's thinking, and, the practical side of things.
And importantly, make sure you remember the crucial details, the judge. The year, because this is clearly important for you, maybe for exams. Definitely. We need to flag those up. The central tension here is fascinating. An agreement designed for security gets challenged by this really ancient legal rule.
Okay, let's set the scene. The agreement itself.
Right. So back in 1993, Mrs. Berrisford takes on this property from Mexfield Housing Cooperative, 17 Elton Avenue, Barnet.
And the agreement, it wasn't like a standard lease for, say, a year.
No. The key phrase was that it ran from month to month until determined as provided in this agreement.
Until determined as provided. That sounds like the important bit.
It is. It sounds like a monthly tenancy, but then you look at how it could actually be determined, how it could end.
Okay, what were the rules for ending it?
Well, Clause 5 was simple enough. Mrs. Berrisford herself could give 1 month's written notice. Easy.
Right.
But Clause 6, governing when Mexfield, the landlord, could end it, that was really tight.
How so?
They could only terminate if she was seriously behind on rent, like more than 21 days overdue, or if she breached other terms, or if she stopped being a member of the housing co-op. Or, finally, if the co-op itself was dissolved. Basically, very specific, limited circumstances, not just we want the property back.
So fast forward 15 years to 2008, Mexfield wants possession.
Yeah. And crucially, they didn't argue she'd done any of those things in Clause 6. No rent arrears, no breach mention.
They just gave her notice.
They just served a standard 1-month notice to quit. Their argument was, look, this is just a simple monthly periodic tenancy, and we can end it whenever we like with proper notice.
Okay. So the big question is, could they do that? Could they just serve notice, even though the agreement itself said they could only end it for those specific reasons in Clause 6?
Exactly. That's the legal puzzle, and it bumps right up against a fundamental principle of property law.
Which is?
The requirement for certainty of term. It's a really old common law rule.
Certainty of term, meaning a lease has to have a clear end date, or at least knowable.
Precisely. It needs a fixed duration, stated up front, like 5 years, or it has to be tied to an event that will definitely happen, even if you don't know exactly when. The term must be certain or determinable.
Like the famous case, Lays v. Chandler.
That's the classic example, yes. 1944, the lease was for the duration of the war.
But nobody knew when the war would end.
Exactly. Or so, uncertain term, void lease. And this isn't just ancient history. Even back in 1563, a judge, Anthony Brown Jay, said a lease needs certainty in its start, its duration, and its end.
Wow, 1563. That rule has legs.
It really does. And it was hammered home again much more recently in 1992. Prudential Assurance v. London Residuary Body.
That happened there.
The House of Lords, the top court back then, really doubled down on it. Lord Templeman said something quite memorable.
Oh, yeah.
He said 500 years of judicial acceptance of the requirement that a term must be certain applies to all leases and tenancy agreements. Pretty unequivocal.
Okay, so based on Lays v. Chandler and Prudential, Mexfield's argument that Mrs. Berrisford's agreement had an uncertain term and was therefore just a monthly tenancy they could end. Well, it sounds pretty strong.
It does seem strong on the surface. If the term is uncertain, it might be void as a fixed-term lease, potentially leaving just a periodic tenancy terminable by notice.
But there's always a but in law, isn't there?
There often is. And here, it involves digging into another, less commonly known, bit of old common law.
What?
The idea was that if you granted an uncertain term, but you granted it to a natural person, an individual human being.
Not a company.
Right, specifically not a company, then the law sometimes treated it differently. It could potentially be viewed as a tenancy for life.
The tenancy for life.
Are you serious?
From a monthly agreement.
It sounds strange to modern ears, definitely, but the logic has deep roots. We're talking 15th century legal texts like Littleton on 10 years.
What did Littleton say?
He discussed things like a lease granted for as long as the landlord remained an abbot. The thinking was, well, the abbot will eventually die or cease to be abbot, so the tenant effectively has an interest tied to that person's life or position.
So the uncertainty gets resolved by linking it to a human lifespan.
Kind of, yes. Or at least that was the potential interpretation. Koch on Littleton expanded it, suggesting grants lasting until marriage or until a debt was paid could also create life estates, assuming the formalities were right.
Were there actual cases on this?
There were mentions. In an early 19th century case, Doody Warner v. Brown, the judges acknowledged this possibility that an uncertain term for an individual could be a life tenancy, but they noted the specific legal steps needed back then hadn't actually been taken in that case.
Okay, so it wasn't a guaranteed outcome, but the idea was there.
Exactly. This background thinking that uncertain terms for individuals might be treated as life tenancies was definitely part of the legal landscape leading up to the big property law changes in 1925.
The Law of Property Act, 1925. That sounds important.
Hugely important. It aimed to modernize everything. And Section 149, subsection 6, that's the absolute key here. Section 149.
Section 149 is at the LPA, 1925. Okay, what does it do?
It specifically deals with these leases for life, or agreements for leases for life that might have existed under the old law, or even ones created after the act.
And what does it do with them?
It converts them. It says any such lease or contract for a lease granted at a rent automatically takes effect as a lease for a term of 90 years.
Wow, 90 years. So it imposes a fixed term.
A very long fixed term, yes. But it's determinable. It ends sooner if the original lessee, the person whose life it was originally tied to, dies within those 90 years.
How does it end then?
After the death, the landlord can give at least 1 month's written notice to terminate it, usually timed for one of the old quarter days.
Okay, so Section 149.6 turns these uncertain life tenancies into 90-year leases, ending on death or notice after death.
That's the mechanism, and this is precisely what the Supreme Court focused on in Mexfield.
Led by, we need to lock this in.
Led by Lord Newburgh. His judgment was delivered on November 9th, 2011. That's a key date and name for you to remember. Lord Newburgh, November 9th, 2011.
Got it. Lord Newburgh, November 9th, 2011. So he applied Section 149.
He did. The reasoning went like this. Ms. Berrisford is an individual. Her agreement had these very specific limits on when the landlord could terminate, Clause 6. Under the old common law, before 1925, this kind of arrangement would likely have been interpreted as creating a tenancy for life, because the endpoint tied to those specific events was uncertain.
Right, because she might never fall into arrears or breach the terms.
Exactly. So uncertain term plus natural person tenant, likely life tenancy pre-1925. Therefore, Lord Newburgh concluded in his November 9th, 2011 judgment, Section 149.6 kicks in automatically.
And turns it into?
A lease for 90 years.
Just like that.
Just like that. Statutorily converted. So Mrs. Berrisford wasn't just a monthly tenant. The Supreme Court held she actually had a 90-year lease.
Which could only end.
Only if she died within the 90 years. And Mexfield then gave notice. Or if she gave notice under Clause 5. Or if Mexfield could actually prove one of those specific grounds under Clause 6, rent arrears, breach, etc.
Which they hadn't done.
Which they hadn't done.
So their simple notice to quit back in 2008
was invalid. Completely ineffective. Because her legal interest wasn't a monthly tenancy that could just end at will. It was this 90-year statutory lease.
That is quite a transformation. A massive outcome for Mrs. Berrisford.
Absolutely. It gave her significant security of tenure.
But you mentioned earlier, this only works for individuals, right? Not companies.
That's a critical limitation. Absolutely crucial. This whole tendency for life underpinning relies on, well, a life, a natural human lifespan.
Companies don't have those.
Correct. They can exist indefinitely or be wound up for various reasons, but they don't have a natural life in the same way. So, the Supreme Court was very clear. If Mrs. Berrisford had been a company, or if both parties were companies.
Then what?
Then the Section 149 logic wouldn't apply. We'd be back to the basic rule. Uncertain term means the lease is likely void, ab initio void from the beginning, under Lease v. Chandler and Prudential.
So for companies, the old certainty rule still bites hard.
Pretty much, yes. That distinction between natural persons and companies is fundamental to understanding the scope of the Mexfield ruling. It doesn't abolish the certainty rule generally. It carves out this specific statutory exception for individuals based on that historical life tenancy idea.
Okay, that's a really important point to flag up, especially if you're thinking about exam scenarios. The nature of the tenant, person, or company is key.
Absolutely. And it also clarifies something about periodic tenancies. Normally you think monthly tenancy, monthly notice. But Mexfield shows that if the contract puts specific restrictions on the landlord's right to end it, those restrictions matter, especially with an individual tenant. It's not automatically just terminable at will.
So the specific terms of the agreement really come under the microscope.
They do. Now let's circle back to the main judgment again. Lord Neuberger, November 9th, 2011. We need to be sure about his reasoning.
Right. Walk us through the steps again. How did Lord Neuberger get from that monthly agreement to a 90-year lease?
Okay. Step 1 was contractual interpretation. Lord Neuberger looked closely at the words "until determined" as provided in this agreement, and clauses 5 and 6. He decided that, read naturally, this meant the only ways the agreement could be ended were the ones specified. Mexfield didn't retain a general background right to just give notice.
So honoring the specific bargain the parties seemed to make.
In effect, yes. Step 2 was acknowledging the problem this created. If it could only end on those specific, possibly never occurring events, it looked like an uncertain term which the common law dislikes.
The Lace v. Chandler problem.
Exactly. But then, step 3. Lord Neuberger brought in that historical rule about uncertain terms granted to natural persons being treated as life tenancies. He reviewed the old authorities Littleton, Koch, the cases, and concluded this was the likely position before 1925, which led directly to step 4, applying Section 149 of the Law of Property Act 1925. Because it would have been a life tenancy pre-1925, the statute automatically converted it into that determinable 90-year term.
It's a neat chain of logic, even if it relies on some quite old law.
It is. It connects the specific agreement to historical principles and then to modern statutory intervention.
Now, you mentioned a memory aid, fate. How does that fit in?
Ah, yes, fate. It's a useful checklist, particularly if you try and analyze a situation quickly, maybe in an exam context. It stands for F, fixed term, or as in Mexfield, a converted term like the 90 years, a actual exclusive possession, the tenant has control. T, tenant, is a person. This is the crucial Mexfield element, not a company. E, entitled to occupy under a contract, usually involving rent.
Okay, let's test it on Mrs. Berrisford.
F, fixed converted term, yes, the 90 years via S1496. Actual exclusive possession, yes, she lived there.
Yeah.
Tenant is a person, yes, Mrs. Berrisford, an individual.
Yep.
Entitled under contract with rent, yes, the occupancy agreement involved rent.
So fate fits. That's helpful. Okay, thinking about exams or just testing understanding, what kind of questions come up around Mexfield?
Well, the most obvious one is simply explain the reasoning in Mexfield.
And the answer needs that chain. Uncertain term in the contract, historical life tenancy rule for individuals, Section 149(66), conversion to 90 years. And mentioning Lord Neuberger in November 9, 2011 would be essential.
Absolutely. Another one, discuss the implications for periodic tenancies.
Right. And the key there is that Mexfield shows contractual limits on the landlord's termination right can override the usual terminable by notice assumption for periodic tenancies if the tenant is an individual.
Exactly. Then there's the company question. Could Mexfield apply if both parties were companies?
And the answer is a clear no, because the life tenancy concept doesn't work for companies, so Section 149(6) isn't triggered. It would likely just be void for uncertainty.
Spot on. Another common pairing is Mexfield and Street v. Mountford. How do they interact?
Okay, Street gives us the basic ingredients for a lease exclusive possession, term, rent. Mexfield deals with a specific problem within the term requirement. What happens if the term is uncertain, but the tenant is a person? So Street defines, Mexfield refines a specific aspect for individuals.
Good way to put it. And finally, the more analytical question. Does Mexfield promote or undermine certainty in property law?
Yeah, that's the tricky one. You could argue both ways.
Go on.
Well, it gives certainty and security to tenants like Mrs. Berrisford, which seems fair. But it relies on this old, slightly obscure law that might surprise landlords. And this split between how individuals and companies are treated adds complexity, doesn't it? So maybe it makes things less predictable overall.
That's a very balanced assessment. It highlights the tension between protecting tenants and maintaining clear, predictable rules for everyone. It's a classic legal balancing act.
Okay, let's try putting this into practice. A quick problem scenario.
Perfect. Let's say we have Lena. She's an individual. In 2018, she moves into a flat owned by Hope Housing Co-operative Ltd. Her agreement says she pays rent monthly. Lena can leave with 1 month's notice. Hope Housing can only ask her to leave if she stops being a member of the co-op or if she sublets the flat without permission.
Okay, so again, limited grounds for the landlord to terminate.
Exactly. Now it's 2024. Hope Housing wants to redevelop the block and gives Lena 1 month's notice to quit, just stating redevelopment plans as the reason. Can they do that? Advise Lena.
Right. Okay. Thinking IRAC issue. Is Hope Housing's notice valid? Rule. We need to apply Mexfield v. Berrisford, specifically the principle established by Lord Neuberger on November 9, 2011, involving uncertain terms, natural persons, and Section 149.6 LPA 1925.
Good start. Application.
Application. Lena is an individual, a person in sate. The agreement has an uncertain term because Hope Housing can only terminate on specific grounds, not being a member, subletting, which might never happen. Under Mexfield, this uncertain term granted to an individual likely triggers Section 149.6, meaning Lena probably doesn't have a simple monthly tenancy. She likely has a 90-year lease, determinable on her death, or if she gives notice, or if one of those specific Clause 6 type events actually occurs, losing membership, subletting.
So the conclusion.
Conclusion. Hope Housing's notice, based simply on redevelopment plans, is invalid. They cannot terminate the lease that way. Lena is likely secure in her tenancy unless one of the contractually agreed grounds arises.
Excellent. That clearly applies the Mexfield logic. Now, what if we tweak the facts slightly? What if the tenant was a company? Lena Ltd.
Okay, yeah, then the T in fate fails. Tenant is not a person. The Mexfield reasoning based on life tenancies in Section 149.6 doesn't apply. It would likely be an uncertain term, potentially void, or maybe just a standard periodic tenancy terminable by notice, depending on other factors. Mexfield wouldn't save the company tenant.
Right. What if the agreement also had a general clause saying, this tenancy can be terminated by either party giving 1 month's notice alongside the specific restrictions?
Contradictory clauses. That makes it much harder. A court would have to interpret the intention. It's possible the general notice clause might be seen to override the specific restrictions, making it a standard periodic tenancy. Mexfield might not apply if there's a clear general right to terminate.
Plausible. What if Lena paid no rent?
Ooh, tricky. Rent is usually essential for a lease under Street v. Mountford. The E in fate, sort of. If there's no rents, maybe there's no lease at all, just a license. If there's no lease, the Mexfield analysis about converting the term might not even get started.
Good point. Rent is a factor. What if the agreement was explicitly for a fixed term, say 5 years, but still had the clause restricting Hope's ability to terminate early only to those specific grounds?
Well, then the term is certain it's 5 years. Mexfield is about uncertain terms. So the 5-year term would stand. The restrictions on Hope terminating during that 5-year term would still be valid, meaning they couldn't end it early just for redevelopment. But Mexfield and the 90-year conversion wouldn't be relevant because the initial term was fixed.
Exactly. You've got to identify if the term itself is uncertain first. Final twist. What if Hope Housing argued they never intended to create a 90-year lease, and Section 139.6 shouldn't apply against their intentions?
I think Lord Neuberger addressed this, didn't he? The intention wasn't the primary focus. The legal effect of creating an uncertain term for an individual was what triggered the statute. Section 149 applies automatically by operation of law, regardless of whether the landlord wanted or foresaw that specific outcome.
Precisely. The statute overrides the party's likely intentions once the specific conditions, uncertain term, natural person, tenant, are met. Okay, one last check on the key personnel. The judges who heard the appeal.
Right. The panel was Lord Hope, Lord Walker, Lady Hale, Lord Mance, Lord Clark, Lord Dyson, and, crucially, Lord Neuberger.
And who gave the leading judgment and when?
The main judgment, the one we've been focusing on, was delivered by Lord Neuberger on November 9th, 2011. Let's say that one more time for good measure. Lord Neuberger, November 9th, 2011.
Perfect. Hopefully that's lodged firmly in your memory now.
So wrapping up this deep dive on Mexfield v. Berrisford, what's the absolute core message to take away?
I'd say it's this. Don't assume an agreement that looks like a simple monthly rolling contract is one, especially if the tenant is an individual and the landlord's power to end it is tightly restricted by the contract itself.
Because, thanks to Lord Neuberger's judgment on November 9th, 2011, applying that historical life tenancy idea and Section 149 of the LPA 1925,
it might actually be a 90-year lease, only ending on death or according to those very specific contractual clauses. Remember the person-company distinction and maybe use that FATE acronym.
F fixed converted term, A, actual exclusive possession, T tenant is a person, E entitled under contract rent. Got it.
So a final thought to leave you with. We've seen how Mexfield tries to protect individual tenants by drawing on old law, but also how it creates complexity and treats individuals differently from companies. Does this ruling strike the right balance, do you think? Is it fair to landlords? Is it predictable enough?
Or does it maybe highlight a need for clearer rules altogether when drafting these kinds of agreements? Lots to think about there. What other questions does Mexfield v. Berrisford raise for you about how we structure agreements for people's homes?